Hi, everyone, and welcome to another Facebook Live here on Friday. My name is Kevin Mason. I'm a TuckerAllen attorney, and today we are joined by Nina Windsor, who is our managing attorney. She's based in the St. Louis area. Thank you, Nina.
Hi, Kevin.
And just like every week, I'm going to give the disclaimer that we always give, which is that these are just short sound bites here that we're producing. They're meant for educational purposes only. If you have some more questions, if you need to speak to an attorney, find one in your area and call them, or give us a call. We would be happy to help, but this in no way are we creating an attorney-client relationship. This is solely for educational purposes. So with that being said, today we're kind of going to dive into and talk a little bit about what ancillary estates are. And kind of how to avoid them and just all the good stuff that goes along with them. So with that being said, Nina, what exactly is an ancillary estate?
So everybody talks about probate like it's the most stressful thing you can possibly have happen after a loved one's passing. Mm-hmm. And this is just, that's kind of having all of your assets in one state. That's basically, that's the JV version. Because when you start talking about having assets in multiple states, it is varsity level probate, and it is to be avoided at all costs. So an ancillary estate is an estate that has to be opened in a second or even third state because your assets are titled or located not in the state where the person passed away, so not in their state of domicile. So, for example, let's say that you have all of your assets, all of your accounts, your primary residence is located here in Missouri or in Illinois. And then you have a house that you've decided to get for vacation purposes, and you may rent that out or something, but it's titled into your name. And when you pass away, that asset is real property and it is not located in the state of your domicile. So it can't be handled the same way the rest of your assets would be in probate. And the issue with that is that it can be a piece of real property. It can even be a car that got registered somewhere else. And people don't always re-register their cars in their state of new domicile if they've moved. So it's more common than you might think.
Sure. Yeah, absolutely. So basically what we're dealing with here is a piece of real property that's just located in a different state than your primary residence. So we've got to have multiple probates going on at the same time.
Exactly. Yeah. So then you're juggling that as the administrator of the estate.
Okay. I already don't like the way this sounds. So I guess my next question is, how common is it really to need an ancillary estate?
So it's more common now than you would think, because with investment properties or properties in which you have, an interest or something has been passed down to you by someone else, you may have this property that you don't use very much, but it's out of state. And now that those can be income producing properties, it's more common because the income can oftentimes offset a lot of the expenses for having those additional properties. And so if they are not titled properly or planned for properly, it can just kind of sneak up on you that people weren't anticipating that they were going to pass. And so they didn't do any planning for these properties, and now it's somebody else's headache.
Okay, so immediately I'm sensing that this is a large hassle. I guess if you could give me a rundown on just kind of what are the main drawbacks to having to open up this ancillary estate in a different?
Yeah, so it's such a fun topic to talk about all of the negatives here, but it's enough to scare you to do the right thing, right? So what they are is, the major drawback is it's not optional. Once you've been appointed as the representative for an estate, you have to gather up all of those assets. And so if an asset is located in another state, you are required to handle that. And usually that is handled with an ancillary probate. So if you're taking care of all of the other assets, you now have to figure out how to handle it in another state. So if you have legal representation in the state where the person passed, in that state of domicile where your primary probate action is pending, they will probably help you isolate the need for an ancillary estate. But they won't be able to represent you most likely unless they're also licensed in that state. So if you have property in Missouri and the property is located in Illinois for the ancillary estate, that might not be that bad. You may be able to find an attorney. Many of us here have licenses in both Missouri and Illinois. But if you're here in Missouri and the property is located in Florida, then you're going to be talking about finding a Florida attorney. And so now you've just amped up the cost of this probate quite a bit. Even if it's not a completely complicated process, you have to retain this new attorney. And now you have two attorneys that are working for you who will also have to speak to each other. And, so that just starts the costs coming in to get a lot higher. And as much as your attorney in the state of domicile would like to be helpful, they're not allowed to give legal advice or enter an appearance for you on behalf of you or the estate in a second or third state unless they're licensed there. The other thing is that having that out-of-state property, we have our 6-month period, which seems long enough as it is for notice to creditors and being able to kind of liquidate assets and get things wrapped up with an estate. That's the absolute quickest it can happen here in Missouri. But if you have a delay in getting authority as a trustee or legal representative because you're opening up this ancillary estate, you have to wait for that to be settled before doing your final accounting. And so it can also make it very difficult waiting for those letters or the authority from the court in the other state to manage things, to manage a property, because it's usually real estate and there are things that will need to be done, and you will not have authority to take care of those things until you have an appointment from the court. So even though it can drag the process along as far as wrapping it up totally, it also can delay that initial authority because you have to open up the primary probate first before you can open and get letters of authority in the secondary and the ancillary estate.
Yeah, okay. So what I'm hearing here is it is a large hassle just because now we're going to have to be paying another attorney, and or most likely we're going to need to be paying another attorney somewhere else. And it's just going to, drag out this probate process even longer, which, 6 months feels like a long time to me. And I know that oftentimes, it takes even long, almost always it takes longer than 6 months.
Yes, that's the absolute shortest it can possibly be. So you're probably looking a lot longer when you start having to look at coordination between legal counsel. And again, those fees just start racking up. And so it is something to be avoided. So, how do we avoid this?
Yes, exactly. That's the big
let's
question.
just cut to the chase. How do we not have to deal with all these hassles? Because it is avoidable. That's the good news.
Okay.
Make sure that your property is jointly owned. That's not always feasible if somebody is the second to die out of a couple, but sometimes people will add, if they only have one child, they'll add the child to the property with them. It's titled as jointly titled with rights of survivorship. And that way, if they pass away, the property automatically goes to that child.
Okay.
So that's, between spouses. If a couple owns the property, then the other spouse will usually inherit that property. It'll pass to them automatically. You don't have to deal with an ancillary probate then, even if you're dealing with a primary probate for other assets, if there are some issues there. In a trust. So you can have the property in any type of trust, but in most commonly, it would be just titled to go to your revocable trust at your passing along with other assets, and it'll be handled without probate in your primary state of domicile or in an ancillary estate. So having that revocable trust allows you to plan for assets in multiple states.
Okay.
A quick way of doing this, even without an attorney involved sometimes, is to just have a transfer on death deed. You can have this prepared and it basically is a beneficiary deed for your property. And that's something that an attorney can take care of for you, either at the same time as you're dealing with other assets or otherwise. And a beneficiary deed can go to a person or to a trust. Of course, one of the things that we'd like to make sure of is that if a beneficiary deed is going to an individual, there can be issues if that individual that it's going to has also passed at the time that the owner of the property has passed. So a trust is still the safest bet, even with a beneficiary deed, if it transfers to a trust on passing.
Gotcha.
But the most important thing is to talk about all of your assets and not just the most valuable ones with your estate planning attorney. So even if you've got some little cottage somewhere that, it's been in the family, it's only worth $100,000, like you definitely don't want to spend a bunch of attorney's fees dealing with transferring an asset that's small any more than you want to deal with it with an asset that's big, but it's almost a bigger hit when you're like, this isn't even that big. Or a car, to spend a bunch of money trying to transfer a car that may not even be worth very much. So, just make sure that the time and expense can be avoided for your loved ones after you've passed it at all costs, because it really is a lot simpler and cheaper up on the front end to plan for these issues than to have to scramble and get a bunch of professionals lined up to deal with a complicated and kind of annoying process later on.
Well, all right. Well, that sounds great. And that was very informative. So thank you so much for your time today, Nina. Like I said, if anybody has any questions, feel free to give us a call at TuckerAllen or visit our website. But again, if you have any legal questions, make sure you go ahead and reach out to an attorney to get those answered. So with that, thank you, Nina. Have a great weekend.
Thanks, Kevin. You too.